Hello everybody and welcome back to the Law of Trusts. In this lesson we are going to be moving on to topic 6 of our subject area, which is of course the introduction to charitable trusts. We're going to talk about charitable trusts in more detail throughout these next few lessons, the different types, the different ways in which we can determine whether something is a charitable trust or whether it isn't, and the benefits of establishing a charitable trust, of course, for charitable purposes. So this is topic 6 in our series on the law of trusts. This topic is going to cover the rules and regulations which pertain to trusts created for charitable purposes. Now, charitable trusts, as the name may be, are trusts that are created for charitable purposes, okay? And the idea behind a charitable trust is that unlike when we talk about private express trusts, one which is charitable will benefit the public or at least some kind of public cause. It doesn't necessarily have to benefit everybody. We'll get to examples where we see charitable trusts for the advancement of, say, education or for the advancement of religion. Now, these can still be considered charitable trusts, even if not every single person in the public is religious or is going through a process of education. But the idea is that it is a public cause. It is not specifically private in that way. Now, private express trusts will only benefit specific individuals, and this is, of course, the beneficiaries under the trust. If you remember back to our very earliest lessons on the law of trusts, you should know already what a trust is. A trust is simply where we have, or at least basic trust relationship is where you have the settlor or the testator who puts property on trust and holds that property, and that property is held by a trustee who then holds that property on trust for the benefit of some beneficiary. They have legal interests, whereas the beneficiary has equitable interests. That's how essentially a trust operates. So there are a number of benefits that you can essentially think about when looking at why you would have a charitable trust. The benefits of creating a charitable trust, of course, is that there are, firstly, different requirements when it comes to the adherence of the certainty of objects. If you remember and think about this, the beneficiary principle, which is something we'll get to in future lessons, requires there to be a beneficiary in the creation of a trust. It's a basic principle, a basic tenement of English law that a trust has to have a beneficiary, a clearly identifiable beneficiary. It has to have a clearly identifiable certainty of objects. And so a charitable trust needn't have that requirement. According to the Charities Act from 2011, Section 69 says that whether there is vagueness as to the object of the trust, so long as the trust is exclusively charitable, the courts may be able to remedy this vagueness, thus allowing for something of an exception to the certainty of objects. So really, where you have the certainty of objects in the creation of ordinary trusts, you have to clearly identify who the beneficiaries are. It doesn't necessarily have to be a name, but it can be, for example, a class of 2013, for example. That can be considered to be a beneficiary of a trust. But charitable trusts could just be quite vague. The adherence to, the benefit of education, or the advancement of education, the advancement of religion, the advancement of environmental policy or something. And so there isn't this kind of clearly ascertainable certainty of objects. This is something that can be remedied by the courts, given the fact that so long as it is exclusively charitable, we can sort of ignore the fact that there is no certainty of objects and accept the fact that the courts may be able to find exception in that. There can be the indefinite dedication of property for charitable purposes as well. This provides something of a rule to the exception, or at least something of an exception to the rule of the idea of perpetuity, the rule against perpetuity, something that we will discuss in future lessons. There are also tax advantages when it comes to the creation of charitable trusts. There are certain tax breaks and tax loopholes, or at least tax benefits and tax remedies that can exist in relation to the creation of a charitable trust. So let's think about where the source of regulation comes from in relation to the idea of charitable trusts. And we can look at the Charity Commission, of course, as one such example. Arguably, the main source of regulation is, of course, the Charity Commission. While it is ultimately the courts that will come to specific conclusions about the nature of A or B being a charitable trust, or whether or not they have purposes that may go beyond that of charitability, and so as a result of which may not fall into the concept of being exclusively charitable, it is the Charity Commission that does have an influence in the ways in which charitable trusts are created and for which purposes they can be considered to be charitable. So we'll get to the Charity Commission in more detail in future lessons, but it should also be noted and important to note that when we look at what is a charity and how we define a charity, we have to talk about the Charity Commission, and we have to then talk also about the Charities Act from 2011.